Section 44 changes how UK inheritance tax applies to non-UK connected individuals. From 6th of April 2025, it replaces the traditional domicile test with a new residence-based approach for determining excluded property status. The cornerstone of this new system is the concept of being a long-term UK resident. An individual meets this definition if they were UK resident for at least 10 out of the previous 20 tax years. This status directly affects which assets fall within the scope of IHT. However, the legislation provides two important exceptions that allow individuals to avoid being classified as long-term UK residents. Firstly, if they were non-UK resident for any 10 consecutive tax years during the 19 tax years before the current tax year. Secondly, through the tail period exception, where individuals who leave the UK can avoid long-term resident status after being non-UK resident for a specific consecutive period. This period ranges from 3 to 10 years, scaling up based on how many of the last 20 tax years they were UK resident before departure. For young persons under 20, the rules are proportionally adjusted since they cannot have a full 20-year history. The calculation substitutes the number of years they've been alive for the standard 20-year period, with the threshold being half that number, rounded up if needed. Children under 1 year old immediately before a tax year receive automatic exemption from long-term UK resident status. Corporate bodies are classified as long-term UK residents if they are either incorporated in the UK or were subject to UK corporation tax on income in the previous tax year due to UK residence. For historical residence determinations, pre-2013 to 14 years follow income tax residence rules of those periods, while later years apply the statutory residence test established in Finance Act 2013.